Good afternoon, lovers of liberty. Um, Developing things that just keep happening. I mean, it's going quicker and quicker. Um, you all saw how big of a file that we had already on what's been filed. I just received this morning, filed by the same Dewey, Cheatham, and Howell law firm. Or no, I'm sorry, it's Warner and Across and Judd, Dewey, Cheatham, and Howell. Um, just filed this on everyone, and basically here's what's going on. Uh, David Mosby has filed a contest with the Michigan GOP credentialing committee, which is exactly the same committee that in August Brent Leiniger and his group filed a contest with, and they won. They won their argument, and we were punished, and they allowed Brent Leiniger's 13 delegates and 13 alternates to go to state convention. At that convention, there was a problem with the Macomb delegates as well. A motion was put on the floor, and I have to understand a state convention is like a board of directors meeting. All the shareholders and board are there, and in any corporate meeting, it doesn't matter what it is. If there's a supermajority to pass something, then that's the direction of the corporation. That's the way it goes. A motion was put on the floor to throw 200 of the Macomb delegates out and bring in 200 other ones because of a similar situation there is what's happening here. And it was an 86% vote to do so. Now they knew that was going to happen with Hillsdale too. The problem is Hillsdale, if they went 1 minute over in the convention hall, it was going to cost them $150,000. They didn't have the money, and they came to John Smith and the delegates that we had there, and they said, "Look, work with us. We don't have the money to hold this thing any longer, and we know that there's going to be a motion put on the floor to have you guys replaced, or to have the Brent Leiniger's 13 replaced with Darren Wisely's 13." And they knew it was going to happen because we had a supermajority there, supermajority of patriot-loving, America First people. And you only need 66.6% to have a supermajority. They had an 86%, 82 or 86%, somewhere right around there. And that happened at the state convention. So that's when Ron Weiser gave us the first letter. It said we were the party, and basically the Brent Leiniger and that group that met on 825 were not seen as legitimate. And they weren't seen as legitimate because they didn't follow the bylaws. Now, let's just kind of do a quick recap of what's going on here. They accuse we caught them trying to disenfranchise the voters by not letting our applications at the county clerk's office be put on the ballot. Keep our people off the ballot. And they were keeping our people off the ballot for their own people. Marnie Cass reduced our delegate pool from 133 to 100, two less than what the Democrats have. So we knew what was going on. They say that we didn't follow the bylaws, and I'm here to tell you we probably didn't follow them 100%. I've never known in 10 years the party to ever follow the rules 100%. In fact, many times we used to hear Darcy Salmon used to say all the time, well, we can suspend the bylaws with a 2/3 vote of the people here. And Steve Veer agreed with that. And so we did quite often do that. So did we violate the bylaws? We probably did. We probably didn't follow them to a T. We did the best we could. And they're saying that we violate election law by not allowing them to the convention in August. Well, we felt that we had followed everything properly. We felt that we, under Article 7, Section 4, disavowed them prior to the election. If they were disavowed prior to the election, then they weren't really Republicans when they were voted on. Our whole contention was we didn't have a problem competing, but let our people compete with their people. Let our people be on the ballot right along with them. but they didn't want it that way. They wanted to sweeten the odds on their side, make sure that they had the supermajority within the local party to take over the party. And that's what this was all about. So they filed a contest with the credentialing committee and they won. Now, their convention that they held in the parking lot was a rump convention. And under the First Amendment, they have the right to assemble. And so we didn't have a problem with that. They could have a rump convention. And then we'll let MIGOP decide, the credentialing committee. And they did. And it went to MIGOP, and MIGOP found for them at that convention. And we were punished administratively by their delegates being picked over ours. Now, our letter from MIGOP, they said, oh, that's a forgery. Ron doesn't have the ability to make that decision. But yet now they have a letter predicated on lies that says they're the party. And now they're putting all their eggs in that basket of, well, Ron said we are, so we are. Okay, but our letter didn't mean anything to them. It's the blatant hypocrisy that just really is glaring in this case. We had a convention, didn't allow them there. They had a rump convention. We allowed them to have that under the First Amendment. We let them file a complaint with the credentialing committee to have that taken care of. And they won that complaint. And kudos to them for that. I don't mind competing on a level playing field. But then they filed a criminal complaint against us for violation of election law. And of course, that didn't go anywhere. The Attorney General declined to prosecute, of course. So, because there wasn't anything there. This problem falls under the political question doctrine that says that 1/3 of the branch of government shouldn't be involved in political party decisions. Because if that's the case, if the court gets to decide, then basically the court gets to decide all of your elected officials all the time. And that's not our system of government. That's not the way it's set up. Of course, our founders didn't really intend for us to have parties, but now that we do, and that's the way it's being done, you don't want the courts meddling in that and making the decision for the electorate. And our problem was we wanted the electorate to have a fair vote. We wanted them to have all the choice of candidates that they wanted to. And it was Marty Cast and Brent Leininger and Abe Dane that decided not to do that. Abe Dane actually filled out my daughter's application and approved it. And then the last day crossed it out in red and disapproved it. So we've got more than enough circumstantial evidence. I mean, there's people sitting on death row with less circumstantial evidence. That it was an intentional thing that they did, and they drew first blood by deciding to not have a fair competition in the August election of 2022. So let's go through the blatant hypocrisy here. They had a rump convention. We didn't sue them. They violated bylaws. They violated election law. We didn't sue them. They didn't get their way, and so they've decided to go to the courts to try to sue us. And J.J. Hodshire is paying the bill, which is odd. I don't understand why they've got to be about 40 grand into this thing by now, 40, 50 grand into this thing through Dewey, Cheatham, and Howell. They're not cheap. And sending this out, Federal Express overnight, first class, not cheap either. How many of us did they send it to? So the issue comes to this. In November, well, let's back up to December. November. November 15th, there was a restraining order put on us 6 original officers. We resigned. We didn't get involved. We didn't do anything. The precinct delegates and the other executive committee members got together on the day that the convention was called for by the state, and an ordered convention went out prior to the injunction. They met, they held a convention, and they did a great job. And then they set a meeting to elect officers, and they set elected officers. And so that November convention, they were David Mosby, who ran that convention, invited all of their delegates invited. In fact, he invited more people than he was required to invite, and he invited all of them from that side, and even continuously tried to get a hold of them that side, and tried to heal the hurt here, try to mend the bridges. They wouldn't have anything to do with it. In fact, Brent Leiniger actually put an email out stating that our convention that David was running was the wrong convention, even though on the state website it said 7 South Manning Street at the old Wilson Hall. They were holding theirs at the 4-H building. He sent out an email that said, don't go to that convention. That's not the right convention. Ours is the right convention. Then, when they went to Ron Weiser, they've got right in the paperwork that David Mosby and the America First faction barred them from coming to the convention. By his own email, that's a lie, and he knows it's a lie. And now, this packet that we've got right here, they've stated right in there that they were barred from the November convention, even though David Mosby's proved it in his motion that Brent Leiniger actually sent an email out stating don't go to that one. So they weren't barred from our convention, or they weren't barred from the America First convention. They chose not to come. But now they're lying and saying that they were barred from it. It just simply isn't true. And if you want to see something interesting, he said that they were barred from it in the motion here, and then he signed his name. He signed his name right here under penalty of perjury. So he committed perjury. The other thing, lawyers can allow, if they know that something is patently false in the paperwork and they sign on to it too, then they've violated their bar ticket under the Michigan rules for professional conduct. So I wonder why Dewey, Cheatham, and Howe isn't being sanctioned for that. Now, I used to have some respect even for my competitors, as long as they were truthful. Problem is, most of these guys are not proving to be truthful. I'll admit to the mistakes I've made, but they're intentionally making mistakes and then lying about those mistakes. That's something completely different. So we had a convention, they had a convention on the same day, two competing conventions, which by all logic means one was a sanctioned convention and one wasn't. So if the state said that South Manning was the place to go, then that was the sanctioned convention. Then the other was a rump convention. But let's say they decide that, oh no, they got that wrong, that Brent's was the real convention and ours was a rump convention. Then don't we have the same First Amendment right that they had in the parking lot to have a rump convention? Don't we have the same ability then to file a contest with the credentialing committee and have them make that decision? After all, they are the state party. They are state central. Under Michigan Compiled Law 169.211.6, by definition, the state central gets to pick the local party. It's not up to a judge. It's not up to Brent Leiniger. It's not up to the county clerk. It's not up to your prosecuting attorney. It's not up to your sheriff. It's state central that picks the party because it's a corporation and we are a subsidiary of that corporation. So that's what's going on. They should not have been able to bring this suit because they had dirty hands. What they accuse us of, they've done themselves. We're not disputing that. That's why we never brought a lawsuit on them, because we know that their hands and our hands are just as dirty. Two wrongs don't make a right, and there's no limit to, there's no different pigeonhole levels to sin. Sin is sin, right? So wrong is wrong. So we have admitted to our wrongs, but they continue to blatantly commit wrongs and don't admit to it. In fact, they actually sign their name under penalty of perjury because obviously they know that they're going to get away, just like Mark Wiley did with not getting a warrant for his arrest for failure to appear. So why is it that these elected officials in town feel so entitled, so ennobled, that somehow they're not under the same law as the rest of us? I've been saying this for a very long time, and I don't know whether people didn't see it or they just didn't believe me, but it should be painfully obvious to everybody by now that they are not under the same law. They feel entitled to be above the law. Uh, Benjamin Franklin wrote in a speech when he had an argument against with Hamilton. Hamilton said that we needed to pay the executive um, quite a healthy salary to get the brightest and the best. And Franklin uh, debated him on that on the floor of Congress, and he said, "Look." Or I'm sorry, not on the floor of Congress. This was in the Constitutional Convention. He said, "You know, the there's good, honest, and honorable men that will take these positions." He said, "There's only two things that rule the hearts of man: avarice and ambition, the love of money and the love of power." He said, he said, "Make positions that are both positions of profit and power." And he said, "It won't be the peace-loving gentlemen of this country that will vie for those positions." He said, "It'll be the bold and the violent that will thrust themselves into those positions to be your rulers." He knew this to be true. And we have made all of our elected positions, sadly, positions of power and profit. He said, "If you make them positions of honor, it'll be honorable men that will take them." He said, "If you make them positions of power and profit, it'll be the bold and the violent." And what do we have? What do we see? It's the bold and the violent. We're seeing people using their elected positions to make sure that they get some extra rights or some extra entitlement over the people that they're supposed to be serving. You know, I hear this all the time. Well, they're held to a higher standard. No, they're held to a different standard. A different standard is not a higher standard. And I would be happy with them just being held to the same standard. How's that? How about if we're all just held to the same standard? The standard of the Constitution, the principles enshrined therein. I think that would be perfect. I think that would probably be the best thing to do, but not. So I don't know why this is even going on in the court. There's so many reasons why it shouldn't be. Um, it shouldn't be going on in the court because of the political question doctrine. It shouldn't have ever. Didn't have standing and shouldn't have been able to bring the thing because of dirty hands. We shouldn't be being held in contempt or being drug into court for contempt tomorrow morning and proving our innocence, because that should be part of the fruit of the poisonous tree, because they didn't have standing to start this. Um, they have not followed procedure. Of course, the law professionals have not had to follow procedure, but us laymen that are trying to defend ourselves have been held to the very strictest letter of process, procedure in the law. Um, I don't know if that's just because it's a legal fraternity, and we give those of us that are wearing the same jersey special consideration where no one else gets it. It seems that we've become a society of that, and that's wrong. Um, we're either all under the law or not. We learned all the way back in 1100 that if the king was above the law, then it was evil and oppressive, that the king had to be under the same law as the people. Even though the king had the divine right to rule, the people had a divine right to liberty. And that came all the way from King Edward 1040 with the common law. So just something to think about, what's going on. You've got people that aren't telling the truth, and these are some of your elected officials. If I'm not mistaken, the perjury statute that's under the 750 penal code in the state of Michigan, I believe it's 750.412 or 421, somewhere around there. It says anybody that has to take an oath by statute, and Brent Leininger being a county commissioner, he has to take an oath by statute. If they say anything that's untrue in any matter or thing, it's perjury. It's a 15-year felony. Not only did he say something under statutory oath that was patently false, a total lie. He signed a court document under the penalty of perjury saying that it was true and factual, and it's not. That alone should have the case thrown out. But you all decide. Look, We're going to be in court tomorrow morning at 8:30, and there's 5 of us that have to prove our innocence, that we are not guilty of violating the restraining order. Even though I believe that the restraining order violated my First Amendment right, I allowed it to show that I had respect for the court, for the rule of law, and for the courts. Um, I I don't know that I'll be giving up any more of my rights, but I did that for a very specific point, and that's to show that I had respect for the court. But I'm quickly losing respect for a lot of institutions and a lot of people that have been elected to those institutions very quickly. So you guys decide. Love to see you there tomorrow morning, 8:30. Have a great day.